Hi, I'm John Brakey in the center in the pink shirt. As an election transparency activist from Tucson, Arizona, I've been working for over a decade to make elections transparent, trackable, and publicly verified. I lead a volunteer group, Americans United for Democracy, Integrity, and Transparency in Elections. AUDIT-AZ is our acronym. We act as a legal watchdog for transparency and accountability in Vote County. AUDIT-AZ is comprised of individuals who donate their time, expertise, and efforts to assure that the electoral equipment and vote counting protocols at all levels of government are not vulnerable to hackers, and that the official electoral outcome accurately reflects the will of the people who cast ballots. In this case that you're getting ready to watch, you're going to see how a county works as hard as they can to protect their right to cheat now or in some future election. Thank you.
Is everybody here ready to proceed? Yes, sir. Yes, sir. Okay, this is Civil 2016 3926 Hernandez versus Pima County. We're on for a couple of motions. One is a motion for judgment on the pleadings. Another, I believe, is a motion to strike. And I believe the third motion has to do with the request for scheduling order and disclosure. Counsel, please state your case.
Casey, now you're on behalf of the plaintiffs.
Thank you.
And Mr. Richard Hernandez is counsel.
Daniel Jurkowitz and Karen Friar on behalf of Pima County, Your Honor, and the Elections Director, Brad Nelson, is present.
Thank you. Okay, I've read and reviewed the various motions in this case. I do want to start off with some of the procedural matters. The first would be the Pima County's motion to strike. Do you want to be heard on that?
Only if the court fully wishes argument.
I don't.
Unless Your Honor has questions for me.
I don't. Pima County's motion to strike is denied. I think the matter is important enough, and maybe there is some ambiguity within the special action rules that may have caused some confusion. I would just warn counsel that my reading of the special action rules would comport with the counties, so you need to look at that rule closer next time. Additionally, there's a notice of supplemental authority, which I went through. Is there another motion for briefing and that sort of thing? I'm sorry, discovery and that sort of thing will put on hold until after the motion for judgment on the pleadings. It's your motion.
Thank you, Your Honor.
So this is the argument on Pima County's motion for judgment on the pleadings.
So, Your Honor, since we filed that motion, obviously there's been an intervening event, which is the legislature passed.
When is that bottom of the fact?
It'll be 90 days after the close of session, which we're expecting to be either today or tomorrow.
The closed session is? So it's 3 months from today or tomorrow?
Correct.
Okay.
So because of that, however, we now have additional authority to weigh. The legislature has spoken specifically about ballot images, and that changes the calculus. And so I think that the first point that we argued in that motion, we've changed our position on that because of the new statute. So at this point, Pima County would agree, since this law will go into effect in approximately 90 days, we would agree to an injunction voluntarily to preserve the ballot images according to the election records series schedule.
So do you agree with the court's ruling that these are public records then?
No, Your Honor, I think we would still continue to disagree with the court about that. However, while we have them, we will preserve them like that.
Okay. How do you square that with?
Obviously, if we agree to the injunction, then we'll be agreeing to keep them according to that record.
Right, with this batch, I'm just wondering how you square that with the legislature's statement that these are something that need to be treated like ballots.
Well,
I mean,
it's not entirely clear what the legislature intended through that statute. So, I mean, we look at the legislative history that shows that they're trying to,
I tried to pull that up, but it was difficult to
would you like a
maneuver.
copy?
No, I did it.
Okay.
I mean, the legislative history is sparse. I mean, it's one page that's repeated, and, but I mean, they seem to suggest, or say outright, that this is the equivalent of a ballot, and you need to treat it like a ballot.
And I think that's how, because of that new statute, that's how we would like to proceed going forward. So I expect that the Arizona Secretary of State in the next version of the election procedures manual is going to specifically address that. And so we would ask that if you do enter an injunction on that point, that it be until such time as the legislature or regulations specifically address how that's to be carried out.
Okay. I'll get to that in a minute. I'm a little confused about that or how this case would affect future cases, but your basic argument is that whether or not this is a public record, you're agreeing to keep the records throughout the duration of the case and any appeal, et cetera.
Well, this will be going forward, Your Honor, until such time as law states differently how we're supposed to do it.
Okay. And then you would say that because of the confidential nature of ballots, it's coextensive with these images and the various statutes and the constitutional provisions would suggest that confidentiality reigns over disclosure.
That's the lieutenant's position.
Okay.
And I can go through specifically on all that if the court desires.
Sure, I'll listen to you.
So as the court just stated, we have the constitutional provision which guarantees secrecy and voting. We have ARS 16-1018-4, which states that, and this goes to the plaintiff's argument as to why judgment on the pleadings is inappropriate, is if there's a contested fact. And the one fact is whether or not someone could be identified from the ballot.
Did you in your, you didn't file, oh, you did file an answer. And in your answer, did you dispute that they could not be?
We stated that they cannot be directly identified from a ballot because it does not have a voter's name on the ballot. However, you can be indirectly identified from a ballot.
Okay, how?
We detail that extensively in our brief, but I'll give you.
I read your briefs, but I still don't understand because if somebody knows the count of you, I mean, the example you give is that there's a small, let's say there's a county or a precinct of 10, and they got the ballots and knew that it was a 3-7 split. They could figure out, I suppose, if 5 people are telling them that they voted one way and the other, that there's something not jiving there, and that they could kind of figure out, I suppose, who voted which way. Is that kind of your argument?
A more likely scenario, Your Honor, would be that in that 10-person precinct, all of them voted the same way because demographics. So I would know that if these 10 people voted, 10 people there voted for Trump or 10 people voted for Clinton, I'm going to know that this particular voter, and I know which voters voted there, I'm going to know who that person voted for president.
What does the ballot add to that analysis? You would know that whether or not they had the ballot, right? I mean, you get the people who voted. You know that they all voted for Clinton. I'm making that up, but you know they all voted for Clinton. It's the same exact information. I mean, it doesn't. Having the ballot in the hand doesn't change that. So I don't understand how the identity issue arises from that scenario.
Well, but again, the constitutional provision guarantees.
That's a different issue. I mean, I understand that the legislature has spoken in many different ways that ballots ought to be kept secret.
Right.
In fact, there's a statute at the end, 16-624, that says that these have to be destroyed. It's not a may, it's a shall.
Right.
After all challenges are done, et cetera, the only reason you would ever get your hands on the ballots is for a statutory reason, which is for a challenge. Then they shall be destroyed. You can only use them for one reason, and that's set forth this.
And they're not subject to a public records request for that same reason.
But I don't know that putting your hand, first of all, I'm not sure that it matters whether you can identify a specific person or not.
We agree.
But if it does, I don't know that, I can't figure out a scenario where they would be able to do that by a ballot that can't be tracked in any way to a particular person.
So again, there's additional concerns besides identification. And I do agree with the court that it's immaterial in this case because 16-10-18-4.
Well, I said, let me be clear, that I'm not sure it's material.
Okay.
But, and you're raising the issues in the Washington case.
Well, no, only as to concerns that we can have for the release of ballots. But in 16-10-18-4, it prohibits the release of ballot images. Okay, there's a narrow exception if you're taking a ballot selfie of an early ballot. All other transmissions of ballot images, release of ballot images, as long as you're showing a voted ballot, regardless of whether you can identify anybody or not, that's a violation of that
So,
statute.
if the legislature has spoken, and the constitutional folks have spoken, people who made our constitution, our founders, that this stuff is confidential, then we're done.
That's certainly Pima County's position. And there's also the concerns we raised in our original motion to dismiss, that people can mark their ballots in certain ways, they can pressure them into voting a certain way, and I can verify that. I can sell my vote. There's all kinds of problems with release of images or release of ballots as plaintiffs would have. It's a real problem for our democratic system.
And releasing the ballots would do what? In the context of vote selling and that sort of thing?
So again, if I said to you, Judge, I'm gonna vote for your retention in the next election, and I will write on my ballot something that identifies me, so you can.
Like a happy face?
A happy face. So that you can pull up the ballots and see that, yes, indeed, I voted how I said I was gonna vote. You
Okay.
can see that image. You can see that I did what I said I was going to do.
Okay, and if, do the images that are actually counted that I have held to be public records, or to be records and subject to public records disclosure, requirements, would that capture the happy face?
Indeed.
Okay, do both parties agree, let me ask you, Mr. Mayor, do both parties agree that it's the same image? I mean, it's a copy of the ballot?
That's our belief, but again, we don't have ballot images to verify that. I mean,
Okay.
so
Okay.
it's supposed to scan the ballot and
The actual-
create a picture in a PDF format, I believe,
Of the actual ballot?
of the actual ballot.
Okay.
So again, we have 16-10-18, which makes that a criminal violation. We have, as the court stated, 16-624, which states that after we count those ballots, they have to go into the vault and they're not to come out for any reason except for upon a court order for a contest. We have the Secretary of State's manual provision, which specifically says
And
that.
I didn't have that. I assume what you cited was correct, but I don't have the
I'd
manual.
be happy to provide the court a copy of that.
If I see it. I know there's a statute that requires there to be a manual, right?
Yes. This is binding regulation on Pima County. It's a criminal violation to violate.
Okay. Let me ask you a question. Some of the statutes that, that deal with voting allow people into the voting area and allow videotaping.
No.
No?
That's
Of the
not
county?
Of the county, there's a video camera of the central tabulation area, so that you can see that nothing untoward is going on. You
Okay.
can't actually see what's going on.
So that's sort of, that's the, that's just watch people count and not, it doesn't show the
Correct.
ballots.
We have the new statute, 16-625, which the legislature has passed, which will go into effect in 90 days. And of course, we have Judge Harrington's prior ruling that ballots are not subject to public records request, that the specific,
Did you have a rule?
yes,
Did you say that rule?
yes, and it's C 2008-5016.
Well, it doesn't, it would be persuasive with that.
Right. I'm just saying, the logic there is that there's very specific statutes dealing with ballots that we control over any general public records statute. Right, and we have Berry versus State, 145 Arizona 12, which says that any public record statutes, any specific statutes controlled with the general public record statute, just like any other statute. So those are all the legal protections in Arizona for ballots and ballot images. And Pima County's position would be that none of these are subject to disclosure under the public records laws.
Okay, thank you.
Thank you, Your Honor. Okay. Let's start with a little bit of factual context, which is certainly not contested. My clients have submitted public records requests. That request asked for the cast vote records, which, as well as the ballot image file. And they requested that they be linkable. But let's talk for a minute about the cast vote record, which the county has willingly given. The cast vote record is an Excel spreadsheet with literally hundreds of thousands of lines of entries that describe how the counting machine counted each ballot. And so there is a record that they have been willing to produce that has that. What we're talking about here and what the county has so far been unwilling to produce are the image files that were used to generate that cast vote record. The vote tallies come from the totals from those cast vote records. So what we're talking about is either a file that you can look at and tie to one of those, or a link even. The software is prepared to create a link between the cast vote record and the image file. So that in my client's best of all possible worlds, that's what would be available to them. But the county's not doing it that way. That is what it is. Now, you have already ruled, and I submit correctly, Your Honor, that ballot image files are public records. And we would submit that there's not binding authority, that they are not public records. In that context,
There's actually a case, I think it's late, LAKE, that talks about metadata. And there's no dichotomy between yes because it's metadata, no because it's actual paper, that sort of thing. So I believe that I'm on fairly firm ground when it comes to that part of it. But what about, I guess we're at the disclosure part of it, right? Under Carlson.
Under Carlson.
Under Carlson. And under Carlson, let's see if I have.
Well, I was just getting to that. But as I read the test, Your Honor, it asks the court to resolve, conduct a balancing test between two conflicting interests.
Okay.
On the one hand, the public's right to openness in government. How they went about.
And there's a presumption that it is open.
There's a presumption that it isn't open, and there's a presumption that the public should have access to have adequate knowledge of how they go about doing their business. On the other hand, there are public policy considerations regarding confidentiality of information, privacy of persons, or concern about disclosure detrimental to the best interests of the state. So this is where we get to the issue of whether or not you can identify the voter. Because the only confidentiality issue is not how it's voted, and that's how an individual voted in a precinct is in the cast vote record that they are willingly given. The only confidentiality question, and again, that record cannot be tied to the individual, presumably that's why they don't have a problem producing it. But in terms of the ballot images, if you cannot identify the voter from the ballot image, and that's really what the constitutional guarantee is about. We cited to Your Honor authority. To the effect we cited to Your Honor authority to the effect that the right to privacy in a ballot is the right to anonymity in your vote. And that also is spoken to by, for example, the criminal statute 1018-4 that they're talking about. An individual has they legalize ballot selfies. I would submit to Your Honor, any vote selling scheme would be much more effectively handled with a ballot selfie by somebody. But in all events, it's criminal to put something on your ballot that identifies. It's an actual criminal offense. So when we're talking about protecting persons, what the county's talking about protecting here is the voter who actually commits a crime in marking their ballot so that they can be identified.
Well, let me ask you this, because in many, many ways, the legislature, who is our represented body, they're the ones who are supposed to represent us. It made statements that ballots ought not be disclosed. In fact, after the process is over, it ought to be destroyed. And if the images are the equivalent of a ballot, they're the same thing, they're a photocopy. I call them a Xerox, but it's because I'm a little older. They're the identical image. Wouldn't disclosure violate 16-624? I mean, aren't we actually, if it's the same thing, and in fact, it certainly might violate the new statute, the new legislation, aren't we violating other statutes by saying that this is subject to public disclosure? And how do I reconcile when the legislature speaks and says, thou shalt not, and you're saying, well, it really doesn't matter that much because the underlying issues are this, that, and I think these are public policy considerations, these are privacy interests, these are different.
Well, the privacy interest being protected in those statutes is the right to anonymity.
But you would be entitled to the statutes then, I mean, to the ballots then,
Well,
under your, I mean, it's the same thing, they're the same thing.
I would submit to Your Honor that the public has a right to know, and well, let's make a little bit of a distinction. I think there's a factual question here, whether they are the same thing, and I wouldn't agree they're effectively the same thing. It's a photocopy, yes, but there are different considerations with paper ballots. When an individual, and let's talk a little bit about process here. When there are county votes or there are challenge votes, multiple people physically look at a ballot. There would be party representatives and others. So
That's a necessary part of the process.
that's a necessary part of the process.
Right, somebody's gotta open up the ballots and look at them, put them in the boxes and things, and feed them the machines and that sort of thing, make sure if one falls on the floor, they have to.
Well, and if there's a challenge vote, if there's a question that something didn't stand properly or there's a write-in vote, there's a process through which party representatives, people who are part of the general public and not county employees get to see the ballots, but not touch them. But there's an important piece to that, is you don't want somebody, certainly an interested party, tampering with the ballot in any way. There is no similar such danger, if you will, with respect to digital images, or at least not that I'm aware of. But here we are, and this brings me back to the point of the status of the motion, is we're talking about different factual scenarios. And the county's talking about factual scenarios, I'm talking about factual scenarios. I don't understand how under a Rule 12C, where you assume the facts are as my client pleads them, and the ballots are in fact anonymous. And just as anonymous as the cast vote record, which they are willing to give us, that we can get to a balancing type ruling between those. I would submit to Your Honor that when you look at the context of 161810, there's a whole series of criminal statutes related to when you're at the voting booth. And so that when you go into the voting booth, you're not going to be intimidated, that the interaction you have with the employee in the voting booth who helps you fill out your ballot if you're disabled and unable to fill it out yourself, is that you're not going to be intimidated there. That's in the voting booth before it's in the ballot box.
What about the statutes,
And
after they're done and they're put into a box and they're sealed and locked up, and then they're put somewhere and nobody shall touch unless there's a recount. And then after a recount, nobody shall touch, and then after that, they get destroyed, which is a shall. And what would the legislature be thinking about mandatory destruction of ballots following any challenges to the election? Other than what the county suggests, and that White case, I think, one of the White cases suggests, is that we don't want anybody undermining this stuff once all of the challenges are done and everybody has a full and fair opportunity to challenge the election. We don't want anybody undermining the process after the fact. And what else could the legislature been thinking?
Well, the hold times in the statute come from a federal statute which require them to hold them so for a certain period of time. And there are different competing interests that there's a minimum amount of time that the federal law requires them
I'm
to.
not talking about the time period. I'm
Right.
talking about once, whatever time they choose is done. I mean,
What?
whatever, they say you shall destroy. Not you shall destroy except by judgment, by court order. It says you shall destroy.
And they can be disclosed in the interim pursuant to a court order.
Right. For what, but for what, and shall, with a court order for certain purposes, which is challenging things, challenging the elections and that, which makes
Well,
complete sense.
I don't read the statute so narrowly to be,
Okay, whatever
that
the,
court
whatever the
order.
statutes allow it for, but it doesn't allow it for somebody after the fact wanting to look at the election to test the propriety of these machines and things. I mean, and I assume that ultimately that's what Mr. Hernandez wants. Is, I'm not sure exactly why you want to put your hands on these ballots, but that's, it's kind of, it is immaterial. Because the public's allowed to have whatever they're allowed to have under the public disclosure laws, unless, under Carlson, there's a countervailing interest.
and we would submit the having knowledge of, we've got these thousands of files, hundreds of thousands of files literally from the general election that that have been recorded, and they've given us how they recorded the vote, and there's no access to the actual image files that were how they did it. We simply submit we have a right to know how they went about it. Can we see, if you pull up a file and the corresponding cast vote image, is it getting it right or not? I mean, and it's not about an election challenge per se. There are timelines because government has to move on and life has to move on. But there are also academic interests that could be at stake here.
And again,
And any
and I don't
other
think that
thing.
matters for the analysis. I mean, a person is either entitled to it or they're not. The reason why a party wants it, I don't think is any part of the analysis, at least from what I've read. So,
I agree.
so I guess what I'm getting at is, if the legislature has spoken, that ballots are secret constitutionally. And some of the states say they're absolutely secret, some of them have used, stronger language than our Constitution does. But then statutorily, they're treated as secret both before, during, and after the process is, that is, the electoral process is over. I don't know that disclosing these ballots, and I say ballots / images of the ballots, would be consistent with Arizona law, because Arizona law has spoken that, the legislature has spoken that these things are confidential. And I, as a judge, I only have so much power. And if the legislature has spoken as to confidentiality of these things,
A couple of points. The primary point I would make is, or one of the primary points I would make, is that when we've cited cases from other jurisdictions, we both have.
and I read them.
And the Colorado case is it's Marks v.
Mark V. Koch.
Koch. Yeah, I want to make sure I got the last name right. The Mark v. Koch case. They have a very similar public record scheme to ours, and they have a very similar constitutional provision to ours. And the Colorado's Supreme Court has ruled, or appellate court has ruled, that the ballot images may be, are subject to the public records request.
Well, one thing is that,
And so long as you can maintain the anonymity of the vote.
well, and the constitutional provision actually says, in the Colorado case, no ballot shall be marked in any way whereby the ballot can be identified as the ballot of the person casting it. That's a
And
fairly,
we have a criminal statute that is to the same effect.
it's a fairly discrete statute, and in addition, they're displayed to the public and the Colorado case was different for a number of different reasons. And I looked at the two white, are there two white cases? I think there were.
There are two white cases. There was the one that was cited by the county, which was White v. Skagit, and there was the other white case is White Skagit versus Clark County.
Yeah,
Sorry, say it one more time. What is the second one?
Clark County.
One versus Clark County, one versus Skagit County.
And those courts of appeals came to different conclusions as to the constitutional question.
Right, and the statutes are always a little bit different, the Constitution is always a little bit different.
And their statutory public record scheme is more mechanical, if you will, than Arizona's. It's more binary. It's a public record unless 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. And 10 is you can construct a bunch of other statutes to say that it's out. In Arizona, the public record statute is if you can find something that explicitly pushes it out, it's out.
Right.
Or, and we don't have that here. We don't have an explicit statute saying it's out. What we have are, what the county's trying to do, essentially what the Washington court argued, which is we're gonna take these several statutes relating to ballot security and protecting the ballots of voters under this constitutional regime, and we're gonna construct those into another statute. In Arizona, we go to the balancing test, which under Carlson is the interests of the public to know how they go about doing their job versus what the county is protecting. And what they're purporting to protect is the privacy interest of voters. And there's not the same binary where we can
I don't mean,
construct a statute.
is there a statutory, is there a provision within the disclosure, the public records disclosure scheme that says if it's not allowed by statute, then it's not allowed? Similar to the Washington scheme?
As I
Or is it
read,
just all Carlson?
well, there's, if you have an express, as I understand Carlson and the statutes, if there's an express law that carves it out,
As non-disclosable?
as non-disclosable. And in fact, Carlson cites to specific cases, consumer fraud investigations by the Attorney General are expressly carved out, and Department of Health Services. But after that, we're in balancing land, which gives the, honestly, Your Honor, gives you discretion. And it gives you relative discretion to the Washington
You
state.
can judge to decide the issue, but I don't
Right.
it's not a discretionary choice where one judge would say one and the other judge would say another, and it would be okay for both judges. I mean, it gives me, I have to balance it, so it's really not discretionary, but I have to balance it and make the decision.
And what is the interest that the county is trying to protect? The county is trying to protect the privacy interest of a handful of voters who illegally mark their ballot in a way to identify themselves. What is the, again, what is the interest that the county is trying to protect here? We would submit that the right to know how they've gone about doing this count with these newfangled machines that create these files that are a necessary part of the process is something that outweighs the county's interest in protecting the handful of voters that illegally mark their ballot. And as to the small precinct question, as you pointed out correctly, Your Honor, from the cast vote records, the cast vote record identifies what precinct the votes are from. So you would get to the same result, and they'd willingly give it. So we would, again, just simply submit that what the county is trying to protect is outweighed by the public right to know.
Okay, let me ask Mr. Jurkowitz a couple questions, which is, if somebody is concerned, legitimately concerned, that these machines aren't doing what they're supposed to be doing, that they want to know how sausage is made, right? Many people don't want to know how sausage is made, but they want to know how sausage is made. And they take pictures of these things and they count these images. How would they ever be able to get that information? And are they entitled to that information? I mean, as a citizen of our state, they may want to know that there's some integrity in these machines so that the votes are being counted appropriately. With these statutes in place and with the ruling that you want me to make, how would they ever get that information? Or are they not entitled to it?
You're on a very specific case law that says they're not entitled to get to see how the sausage is made in an election case. Just because you're interested in making sure that and we cited it in one of our responses, that you're not entitled to just get to recount just because you want to recount. You actually have to go through and allege that there was one of the particular violations and then go through that particular, an authorized method by the legislature to do this. The legislature has created a very comprehensive scheme for how to verify that these things are working accurately, including the Secretary of State comes down prior to every single election and checks out the equipment, makes sure that it runs a test net, that it's tabulating accurately. At the end of the election, they were concerned that, you know, we weren't tabulating correctly, that the electronic results would match up with the paper results, so we got a hand count statute where we would randomly pull a number of different precincts. And Pima County does double the minimum required by law of precincts that we hand count. We go and we pull out those ballots and we match them up to the tape totals, so that we find that they're within the margin of error. And if there's an error, it's almost always human error in counting the ballots. So there are ways to verify that the machines are tabulating accurately. And as we cited, in I don't know how many years, 10 years approximately, since we've had a hand count, for every single election we've held, none of our results have been outside of the designated margin.
What is the designated margin?
It changes with each election depending upon the number of votes.
And what
And
if,
that's all set by the state.
and what if the margin of error is smaller than the margin of victory? Is that factored in there?
The public and candidates are prohibited from reviewing cast paper ballots, in part because officials fear that the original ballot could be tampered with by a person with a piece of lead below a fingernail. In Arizona, a court order is needed to recount ballots. Court orders rely on proof of fraud being shown before the court order for ballot access can be issued. Without access to the original cast paper ballots, it is difficult to establish fraud. Essentially, what we have learned from many court cases over a dozen years is various Arizona counties is that the law prohibits recounting paper ballots in any vote challenge. Recounts in Arizona are not permitted unless the initial computer vote is within 0.1% of the number of votes cast. Again, 0.1% or 0.001. That is the strictest standard in the United States. For example, if ballot machines determine candidate A has 4,994 votes and candidate B has 5,006, which is a difference of 12 votes, there would be no automatic recount. 0.1% of the total 10,000 votes cast in the election would require candidate B to win by 10 or fewer votes over candidate A. Furthermore, Arizona law requires that machine recounts be done on the same machines that rendered the first set of results.
There's an automatic recount statute that controls
For that. So your answer to how sausage is made, it's got to be done within the context of a recount of some sort.
that. There is very specific provisions. You get to see. You have a camera into the tabulating room to see. You can watch on the internet.
But you can't watch inside the computer.
You cannot. But that program, we ship that program off to the Secretary of State.
That is not the case. Several years back, Bill Reisner did a deposition in one of the cases on the state elections director on a Rule 30b-6, where we asked for the most qualified person who could explain what the Secretary of State's duties. It came out that the Arizona Secretary of State agrees it is easy to cheat and state laws prohibit them from checking county computers to find out if any counties are cheating. They cannot look at this stuff by law.
So that the Secretary of State has access and can verify that it worked properly. They come down and verify that the machines work accurately. There are a whole host of protections that are provided for in Arizona law. This is not one of them.
I would just submit to Your Honor that one of the wonderful uses of the public records statute would be an academic, for example. When we're talking about an activist group, I just want to put this out there. The public has a right to know that, and what the county is saying is, well, the Secretary of State verifies it, that doesn't help the public's right to know. And we submit that the public, under the public records statute, has the right to know how they go about performing their job. And as long as the individual's identities are protected, there's nothing to protect, and we don't have Washington State.
Okay, I will tell you that, I am concerned about the secrecy involved in elections, but maybe that's just part of the process. I mean, it's statutory, it's part of the process. And I think that my concern lies more with, not secrecy in the process, but secrecy in the machinery. I mean, it sounds almost like a Robert Ludlum novel. I mean, there's certain things that could or might happen that we may never know about. And it bothers me that there's no sunlight on that part of it, and it's all within the context of the state, Secretary of State. That's what bothers me. And I don't know that, that there have been a lot of cases that flesh that out. On the other hand, I'm not supposed to be looking at what somebody wants to do with the material, how important it is to the other side, because that's sort of a presumption. It is a presumption that there should be sunlight on the other side. So I'm gonna take this under advisement. I'm gonna look at cases again. I'll get you out a ruling as quickly as I can. It's not a very complicated ruling, because I've thought about it a lot. For now, I'm denying the other motion without prejudice as to the discovery issues. So I'm denying all of the motions in this case without prejudice, subject to my ruling in the context of the motion for judgment on the pleadings. Do you have anything else that you want to add, either side?
Your Honor, just to very briefly answer plaintiff's counsel's arguments, the interest that Pima County is pursuing here is to follow the Constitution, to follow the state statutes, to ensure the finality of election results and the confidentiality of the votes.
And one of the answers may be is, if the legislature is spoken and you don't like the way the legislature is spoken, you may have to go to the legislature and change the law. I don't know. I need to follow along whatever it is, and figure out whether these records that I found to be public records are subject to disclosure under Carlson and the related law. Okay. Does everybody agree that's the issue?
That is the issue.
Okay. Anything else that we need to do today? Okay, we're at recess. Thank you. And you're on your advisement.